Good morning, colleagues, and welcome to this discussion forum. We're delighted that so many of you can join us today, and you might be interested to know that there have been over 620 different registrations for this meeting. So today we're going to talk about the voluntary POPIA Compliance Framework for researchers and research institutions. I think this is very important to all of us who do research in South Africa. So I would imagine amongst the audience, we have people with legal expertise, we have bioethicists, we have philosophers, we have researchers, and we have those very important people who help us comply with the law. But I think we're all here unified because we want to do meaningful research that we can share with the world. So my name is Michèle Ramsay, and I'm a professor in human genetics at the University of the Witwatersrand. I'm a researcher. Our group generates a lot of research that we share widely, and that is very important for the advancement of science. But today I'm here in my capacity as the chairperson of the ASSAf POPIA committee. So to set the scene, I think it is well known to all of you now that the Protection of Personal Information Act, number 4 of 2013, came into effect in July 2020, with a grace period of 1 year to comply. So we've all been aware that as of July 2021, we have had to comply with the POPIA Act in the context of research. And I think all of us have been doing that through our institutions, but some of us continue to be uncertain about whether what we are doing is the right thing. So Chapter 4 of the POPIA Act makes provision for the development of a code of conduct. And you will all be aware that in the beginning, this was our strategy, to develop a code of conduct that would apply to all researchers in South Africa. But we understand now that this may not be possible. And what we are aiming for is to have an industry best practice for guidance for researchers, and that this will allow us to uniformly interpret how we apply POPIA in the context of research. So there are 5 reasons why we believe that this is really important. And the first is that there is some lack of clarity in terms of how some of the high-level principles in the Act would apply in practice to research. We're also aware that there are exceptions from the lawful conditions of processing personal information, and it is important for us to understand how and when these exceptions apply. Most importantly, we want to make sure that across South Africa, there's a uniform approach in terms of how we apply this information and the guidance, no matter where you are doing your research. And what is very important is for South Africa to be seen as a safe haven for research data. And one of our aims is to request and apply for adequacy with the European Commission. And very importantly, we want to know how researchers and research institutions will be held accountable for non-compliance with POPIA in the context of research. So when we thought about this right in the beginning, when we started this process in 2020, was who would this framework apply to, or the code of conduct as we were talking about then? So it was very important for us in our deliberations that this framework applies both to academia and industry, and that it cuts across all the different disciplines that actually process and collect personal information during their research. And we grappled very much with the definition of research and came up with this broad context of what research really is. And for everybody to understand that typically research would undergo prior independent ethics review and approval, and usually would be intended for publication. So we understand that the code of conduct that we had developed, and now this guidance framework, doesn't sit in isolation, but that it needs to be seen in the context of our legal and ethical framework in South Africa. So first of all, in the framework of the Bill of Rights, where everyone has a right not to be subjected to medical or scientific experiments without their informed consent. So there's a lot of emphasis on informed consent in the guidelines. Then, of course, we work within the framework of the National Health Act, and the National Department of Health guidelines on the ethics in health research. And many of you will be aware that in May this year, the 3rd edition of these ethical research guidelines were published. So it applies broadly to research, not only health research. And having understood that consent is very important, we are also aware that all health research ethics committees need to be registered with the National Health Research Ethics Council. And we want to make sure that we are aligned with international standards to allow open science, but also to ensure that we protect our data. So many have asked the question of why is it that ASSAf became interested in this? And I'm very grateful to Himla Soodyall, who is the executive officer of ASSAf, who decided that she would take this on and support this initiative. And very importantly, for the amazing work done by Susan Veldsman and Maputi Rametse, who have really been the engines driving this process over the last 4 years or so. So the Academy has amongst its objectives to promote common ground in scientific thinking across all disciplines, but also to promote optimum development of intellectual capacity for all people, and to provide effective advice and to facilitate appropriate action in relation to opportunities and challenges in South Africans. So ASSAf views the balancing of the right of privacy of research participants against the collective public interest in the scientific research as an integral part of these objectives above. So what have we been doing in the last 4 years, and where are we now? So importantly, on doing an assessment of all our stakeholders and the people that we've engaged with over the past 4 years, we can say confidently that over 90% of researchers and research institutions have been involved in the drafting of these guidelines. So in 2021, ASSAf appointed 2 committees, and which we've now amalgamated into the POPIA committee, and it's held 32 different meetings. During the period from 2020 to 2024, there have been numerous public consultations, as you can see here. And very importantly, earlier this year, we had a joint event with a CIOMS guideline event. And CIOMS, for those of you who are not aware of what it stands for, is the Council for International Organizations in Medical Sciences. And this is part of understanding that we need to be aligned with international good practice. So from 2021 to present, we've also had lots of public events, including a publication, and we've had a lot of comment and feedback from you as our community. And we're very grateful for all those inputs, and we have tried to give attention to all of them, and where appropriate to incorporate them into new drafts. So you can see that a draft code of conduct had several iterations, and in April 2023, it was submitted to the Information Regulator. And in July, we got feedback from the Information Regulator, and the feedback was that they would not accept the code of conduct as it was. They had no significant problem with the content, but what they were concerned about was representation, because they viewed that only ASSAf members would be represented by this code of conduct since it was being submitted by ASSAf. And as you all know, that was not our intention, that the intention and the scope of the code of conduct, as we had seen it, would have been for all researchers, whether they're in the academic sphere or in the commercial sphere. But for that reason, you know, we could not pursue the code of conduct. And their other concern was about process and who would be responsible for what. So having had this feedback, the ASSAf POPIA committee came together again and thought about the options going forward. And we then presented several options to the ASSAf Council and asked for their advice as to how to proceed. And through guidance from the ASSAf Council, we decided that the best way to go forward was to have a voluntary guidance framework for research in order to have a uniform approach to complying with POPIA in the context of personal information in research in South Africa. And that is what has brought us to where we are now. So again, huge appreciation for everybody's inputs. And we hope that you've all seen the draft document and that we will get your input today as part of this conversation, but that you also give us written feedback, because that's very important for us to improve this document and to make sure that it is fit for purpose for all researchers in South Africa. So 2 hours is not a very long time, so I would like us to move on to the next section. So I know that most of you have read this document, but it is a very good idea for us to have a joint overview. And for this overview, we are lucky to have Ms. Sarah Buerger, who will do this for us. So Sarah is an attorney with over a decade of experience in data protection law, and she's been a key member of Novation Consulting. She's been actively involved in developing and writing the data protection code, and also making the current guidance framework in more accessible language. So we hope that it will be a very useful document for ethics committees, for researchers and research institutions as we go forward. And I will now hand over to Sarah. Thank you very much.
Thank you, Michèle. I'm just going to quickly share my screen. Okay, so what you see before you is the POPIA Compliance Framework. And as Michèle said, it is broad and we can't cover every specific question and every specific situation. And I know we have had some comments saying, you know, can we look at this and can we look at that? And if you do have those comments, please also put them in your feedback, because what we will most probably do is create an FAQ afterwards and then publish that as well, just so that if there are very specific questions which lots of people ask, we can actually answer that and try to provide guidance there. But yes, we have created the POPIA Compliance Framework, and I always find it a little bit funny that we have to dwell on that name a little bit. So we don't want to go into what the ethical guidelines say. We don't want to go into what the National Health Act says, because they have drafted great guidelines and they have drafted things. So we don't want to step on people's toes and say conflicting things either. So we're focusing on POPIA. And how we have done this, you can see, obviously it looks a lot better than the code, because we're no longer bound by the strict formatting requirements that we needed to follow within POPIA. But how we've done this is we've broken it into different sections. So we've got about this framework, which is obviously the purpose and when the framework applies, who it applies to, and that's just going through who the responsible parties are, who the operators are, and chatting about research institutions and independent researchers, and then which sections of the framework apply to you. So what's important here is if you're an independent researcher, or if you're a researcher working for a university or for an institution, you can have a look at section 3. That's got all of the practical content for you. If you are a researcher at if you're a research institution, then you will have a look at that, as well as, sorry, my apologies. If you're an institution and an independent researcher, you will look at section 3 as well as section 4. So that's because you have more responsibility, and you'll need to do more of the thinking. Now, saying that, it doesn't mean that if you're just a researcher working for an institution, you don't need to look at section 4, because you most probably will have to help your ethics committee or whoever's responsible for doing perhaps an impact assessment to answer some of those questions.
Apologies, Sarah.
Yes.
Can you just enlarge your screen a little bit more?
Sure. Sorry. Thank you, Susan. Is that a bit better?
Just a little bit more.
More.
I think that is a tad better. Thank you so much.
Okay. Thank you for letting me know. Let me just quickly show the table of contents again so that everyone can see that. So we've got about this framework, who it applies to, and then section 3 for researchers, and section 4 over here for institutions as well as researchers. And then, of course, we've got a glossary at the end just to make sure that we're all on the same page with the terms. Okay, and now you can see it's a I know when we started drafting this again, it's a lot easier to read. It's a lot more manageable. We've divided into different blocks. We have nice bold text, and we've also got some hyperlinks that you can follow quite easily. So it's a lot easier to read through and to practically help you. So we'll always have what is processing, but then obviously at the end we'll also have a glossary at the end. Okay, so this is basically just saying, you know, when you need to have a look at it and when the research framework applies to you. And then who it applies to, obviously we've got the responsible parties as well as their responsibilities, as the name says, and then operators and who are operators and if and what does that mean. Then just chatting about research institutions and independent researchers. And then here we go, the sections of the framework that apply to you. So if you're a researcher, you look at section 3. And if you're a research institution or an independent researcher, you look at section 4. But also remember that you do have to know what's in section 3 as well. And then the meat of it is basically all in section 3 and 4. And I don't want to dwell on it too much because you'll have this document. And if you do have any questions and answers, we can go through it in the section a little bit later. But it's all your typical information. And like Michèle said, the content has not changed a lot. It's made into a lot easier language. And we can say you and not the research participant and the research subject and all things like that. So it's a lot easier to read. And yeah, so this is all of it. Going through, and you can I'm just going to do a quick scroll through so you can see if there are any important things over here. We put it in there. We also do have some footnotes if need be. And then I'm just going to quickly scroll to section 4 so you can see that, what it looks like. Oh, and one more thing. So we know that there will be many people reading this document. Lots of researchers will not want to go and read more about the rights of a data subject or automated decision making. But we know that people within the legal space or in the ethics committees will most probably want to know exactly, you know, which sections we're referring to. So we have put that in there. Wherever you see that little gavel in picture, so if you want to know exactly where in POPIA or exactly the legal section is, go have a look at that. But otherwise, you don't actually need to look at that. And then once again over here, the A to Z, you've got what exactly is automated decisions. Okay, scrolling down. And yes, things in orange where it says NB are, as it says, are important. And then section 4. So if you're an independent researcher, it talks about responsibilities. And we've obviously got monitoring and compliance and accountability. You can see exactly, you know, who it's aimed at, and the 3-phase research and privacy impact assessment, risk assessments, all the assessment and the monitoring admin-y side of things, and then security compromises as well. And then you've got your glossary. And then just a quick last final comment was once we knew that this was the code wasn't going to be approved, we then had a look at numerous articles that had been written about the code, and we really looked at that feedback and we took it on board and how we were drafting this. So yeah, we appreciated all of those articles that were written, all of those comments that were made on the code, and we really pulled that all together. to create this hopefully nice, accessible, usable framework for all of the researchers in South Africa and hopefully Africa, because it's a nice document to read, and if it is nice and easy to read, more and more people will start using it. Thank you so much.
Thank you so much, Sarah, for walking us through this document and for the hard work of you that you and Novation have done to make this a really useful and user-friendly document. And thank you, Ina, for popping it into the chat so everybody will have access to it immediately if they want to refer back to it. And again, to reiterate that we do need your participation and your feedback to improve it. And we've kept it as brief as possible, and therefore frequently asked questions section will be very helpful for specific sort of scenarios that people want to have addressed. But it's my great pleasure now to invite Eleni Flack-Davison, who will chair the next session. And Eleni is an admitted attorney to the High Court of the Republic of South Africa. She's a legal advisor and a research compliance manager. She's currently head of the Office of Research Integrity and the Data Protection Officer at the University of the Witwatersrand. And she's going to be facilitating our panel discussion today. And we're very grateful that 4 of our very big stakeholders are present here to tell us what they think about the compliance framework. And those are representatives from the Department of Science and Innovation, from the South African Medical Research Council, from University South Africa, and from the National Health Research Ethics Council. So thank you so much, Eleni.
Thanks very much, Michèle. Appreciate it. And good morning to everyone. Thanks very much, Sarah, for the background of the framework. I think it has come a long way. I've seen where it was and where it's come from, and it's really come a far way. And it will set a consistency and a standard, not only throughout South Africa, but Africa as well. And I would like to introduce our first speaker, Ms. Gugulethu Zwane, who is currently the acting Director General for the Departments of Science, Technology and Innovation, where her permanent position is Deputy Director General, Institutional Planning and Support. This branch is responsible for the governance of entities, planning, policy and formulation, monitoring and evaluation, communication, risk management, internal audit, and the offices of Director General and political principles. Gugulethu will be speaking to us on government's role from the aspect of the Department of Science and Innovation. Welcome, Gugulethu.
Good morning. I hope I'm audible.
Yes, you are. We can hear you and see you. Thank you.
All right, thank you very much. I don't have a presentation, but I will be speaking on several aspects in terms of the role of government as far as the POPIA Act is concerned, and also trying to adapt it to be relevant to our space in terms of research. So I think it's important to just go back a bit in terms of why we had to have the POPIA Act in terms of protecting people's privacy and personal information from harm, which we think as South Africa, this is a fundamental human right, and it is therefore everyone's responsibility to make sure that personal information is collected lawfully, used well, retained and disseminated accordingly. So in terms of the department, we think we are in support because this means that we are connected with open science. We recognize that the research landscape is rapidly evolving, presenting new opportunities. So as the department in that is creating policies for the 21st century research system that balances innovation and accountability. Our mission aligns with global open science movement, emphasizing openness, collaboration, and addressing global challenges. Open science is essential today, aiding in health crisis, environmental sustainability, and empowering citizen scientists by sharing knowledge. Digital technology enhances discovery and also maintaining a balance between openness and data privacy is critical to protecting participants and sustaining public trust. Within South Africa, us as the department, we believe that we play a vital role in balancing openness with data privacy, particularly under the protection of personal information, which the compliance thereof is both legal and ethical, is both a legal and an ethical obligation, which is central to our national research objectives. More to this, as the government that is playing an oversight role to ASSAf, we support the POPIA compliance in research framework. It is our responsibility as a governing body whose role is to oversee ASSAf's activities, including the development of this framework, which must align with our commitment to data protection and research. Our financial support to ASSAf demonstrates that the department is invested in initiatives that will ensure compliance with POPIA and also reinforce ethical standards within the research community. We are also looking at part of being promoters of compliance and practicality through this particular framework, and we are in endorsement of ASSAf's efforts. With regard to the DSTI's broader vision for ethical research practices, we see POPIA as a good framework to position compliance, which is crucial to South Africa's national research goals, protecting participants' data, while also fostering a culture of ethical and innovative research. We would want to position the framework as the best practice guide for all DSTI governed research bodies, which will make sure or ensure a consistent approach to data privacy, highlighting the importance of collaborative feedback to refine the framework and ensure that it meets diverse operational needs. We also think with regard to national and global impact, there is a link in terms of compliance efforts to South Africa's national research goals, fostering public trust and ethical standards. This will position South Africa as a leader in ethical research, promoting global collaboration through rigorous data protection practices. And then we also look at collaboration beyond borders, which also embeds robust data protection practices into our research systems, where South Africa can position itself also as a leader in ethical research on the global stage. We would want to continue upholding rigorous data privacy standards, for which fosters public trust, strengthens our research capabilities, and promotes international collaboration, which sends a clear message to the world that we are a country that is committed to leading by example and advancing science in ways that respect and protect all individuals. Also taking into consideration that complying with POPIA has its benefits in terms of data security, improved customer trust and loyalty, reduced legal and financial risk. This applies to businesses in general, but I am sure we can also relate to that within our own spaces as well. Therefore, as the DSTI, we welcome a platform where stakeholders can openly engage on the POPIA compliance framework for research. As much as it is said that it's voluntary, we also see that it's important where there's continuous awareness and hopefully uptake, so that in future We avoid reputational damage resulting from breaches, and also we are better prepared for future changes in data protection and regulations. So that is the message from us as the DSTI chair. Thank you.
Thank you. Thank you, Director General. Really appreciate your input. And it's great to see that the DSI plays a vital role in assisting researchers and innovators to be compliant in the realm of open space while sharing knowledge and the protection of data. It is great to have the department's support and endorsement of this ASSAf framework to be the best practice. And I thank you, Gugulethu, for your input and for more questions later on. Thank you. Our next speaker is Professor Ntobeko Ntusi, who is the brand new President and Chief Executive Officer of the South African Medical Research Council. He is appointed as a Professor of Medicine at the University of Cape Town. He is a distinguished and highly respected figure in the medical community as a key global opinion leader. Thank you very much for joining us, Ntobeko. Over to you.
Thanks very much, Eleni, for that warm and generous introduction. I'd like to start by congratulating you and your many colleagues who have developed this important framework, which I hope will set a industry standard for protection of personal information in science, not only in South Africa, but regionally. And what I'll do over the next 10 minutes is firstly to share our own experience, which is vast in ensuring compliance with POPIA as the South African Medical Research Council, and then end by reflecting on some of the existing gaps that I hope this framework, as it evolves, will help us to address. I would like to start by just reading this history statement from the South African Medical Research Council, where we acknowledge our complicity in the persisting educational and health disparities in this country, and acknowledging these, we commit ourselves to the continued promotion of justice and dignity in health research. So the SAMRC is an object of statute with a vision of building a healthy nation through research, and our mission of advancing research, capacity development, innovation, and transformation to improve the health of our nation is underpinned by our values stipulated on the slide. So what's the relationship between the POPIA Act, the Constitution, and other acts? At its core, POPIA is about giving effect to the constitutional right to privacy. And it does this by implementing safeguards in connection with personal information processed by a responsible party. Therefore, any other act, the provisions of which are inconsistent with the object of POPIA, will always be overridden by the POPIA Act. And many of you will be familiar with this, that the processing of personal information, in order for it to be lawful, it needs to meet the conditions of lawfulness as stipulated in the Act. And the 8 conditions include accountability, purpose specification, process limitation, further processing limitation, information quality, openness, security safeguards, as well as data subject participation. So what has been the SAMRC approach in the last 5 years? We started by performing a landscape survey to assess where our institutions stood and what possible gaps may be in ensuring POPIA compliance. And this was at the beginning of 2021. We outsourced this work to Bowman's, and they came back to us with an extensive set of recommendations, and these included the adoption of an organizational policy and manual. In addition, we developed quite a comprehensive POPIA compliance framework, and I'll share elements of that. And we also developed an internal data subject access request policy. And this has been accompanied by a POPIA committee, which is comprised of individuals that represent the different functional units of the SAMRC. We have regular POPIA internal audits. Even though as the president and CEO, I am the delegated authority, we also have got safeguards via deputy information officers who enable much of our work in this area. We developed a privacy notice, which is available for everybody to view on our website. And we also have got a dedicated website on POPIA, which everybody can see. We run regular workshops conducted by our legal department for all staff, not just scientists. And we also critically have POPIA embedded in our applied ethics training and our internal NHREC processes. In addition to all of these activities that I described, we also undertook quite a rigorous process of converting our audit register to a personal information impact assessment tool. And this stipulates quite clearly what personal information can hold, the reasons for holding it, the process for processing this information, the legal processes that underpin the holding of this information, the security safeguards that exist, the rights of the individuals from whom the information is taken, and of course, the retention period for holding this information. And so from the initial survey conducted in 2021, the key areas related to the absence of a formal POPIA policy, the absence of an internal POPIA manual, the amendment or development of a record retention policy, the notification of data subjects regarding use of their personal information, the inclusion of confidentiality clauses in employment and other agreements, and the identification operators and conclusion of written contracts in alignment with POPIA. And all of these have subsequently been addressed. And so the core elements of our POPIA policy include those on this slide. So the information about who we are as a public entity, the data we collect, how it's collected, how it's used, the disclosures, the international transfer agreements, data security, retention, and of course, legal rights. And we've got a very extensive manual, which is very user-friendly, which supports the policy, which provides a much deeper dive into all the elements I list on this slide. We also have a comprehensive data subject access request policy, which enables a uniform practice that guides how people can access information that we hold on individuals that we do our science on. And this slide summarizes the key components of that policy. And so in closing, I think that there are a number of gaps that exist. Firstly, we hope that this important ASSAf POPIA framework will emphasize the interrelationships of the Protection of Personal Information Act, as well as the Promotion of Access to Information Act, which are interrelated. There are also a number of gray areas within POPIA, which we think need a particular clarification as they relate to science in health. We also think that this is an important framework to enable all institutions that do health research to develop in a uniform way their institutional processes and structures. And by doing so, we hope that ASSAf will be able to harmonize practice across all institutions in our country and in the region. And then there are some instances of conflict between GDPR and POPIA. And my hope is that in the future, this ASSAf framework will also help us to be able to address those. So with these few words, I wish to express our very strong endorsement and to congratulate our colleagues at ASSAf for developing this important document. Thank you so much.
Thank you very much, Ntobeko, and thank you for the SAMRC's endorsement of this framework and the support provided by the MRC as well. And thank you for taking us through the journey and reminding us of the requirements of POPIA and providing the SAMRC's perspective and the journey that the MRC actually has had with the POPIA and what has been put in place. And MRC is a great example for us all to consider in our circumstances and what we can do, because we can learn from each other as well. I thank you for that. Our next presenter is Mr. Jerall Toy, who is from Stellenbosch University, and he is the Deputy Director, Information Governance and Deputy Information Officer under POPIA Empire. Jerall also chairs University South Africa, USAf POPIA Forum, a forum for South African public universities, deputy information officers, and other key sector stakeholders to discuss and collectively troubleshoot privacy and access to information challenges facing the sector. Jerall will look at the framework from a university perspective, University South Africa's perspective. Thank you. Over to you, Jerall.
Thanks, Chair. Let me just share my own slides. There we go. All right, when I was first asked to be on this panel, I reflected on USAf's own journey towards a potential code of conduct under the Act. So way back in 2017, the Information Regulator engaged with the Legal Practitioners Forum. Now that's a forum for the university's legal practitioners. Much as our chair described our POPIA forum, the Legal Practitioners Forum is also a community of practice for collectively troubleshooting matters of a legal nature. And after that engagement with the regulator, USAf decided to establish a task team to understand the impact of POPIA on the sector as a whole. Moving on to 2018, those who remember, the GDPR just went live that year. You might remember all those emails you got asking you to stay subscribed to various newsletters from around the world. And so the task team, one of their first deliverables was to offer a guidance note for South African universities on how to engage with the GDPR. And after that, we began investigating the feasibility of a code of conduct for South African universities. Throughout 2019, we held a series of national workshops to figure out how exactly are we going to tackle this. And now remember, this was before the Act went live, so we were operating under a slightly different framework than ASSAf. But as you'll see on my next slide, I'll go into a bit more detail about why we also chose not to pursue a code of conduct. And so in 2020, just after the go live of POPIA, USAf launched their first edition of POPIA guidelines for South African universities. And to support this in 2021, USAf formed its POPIA Forum. And since then, over the last 3 years, that forum has been involved in many discussions and has created several tools and deliverables for its members, leading up to today, where we are just about to launch the second edition of our university POPIA guidelines. But then why not a code? So as I mentioned, this was way, way back in time before COVID in 2019. We held the view that we could develop something that could serve as a voluntary guideline until such time that the regulator was ready to start considering codes of conduct. And since POPIA was based on a reasonable standard, we held that any possible deviations from the guidelines might be seen as unreasonable behavior by one of our universities. And then if we did succeed in getting it accredited by the regulator, breach or failure to comply with the code would have been deemed a breach of POPIA 2. And of course, if the regulator chose not to accredit, well, then we would operate as before accreditation. And one of our other design decisions was to explicitly exclude research as well. And that's why we're looking at ASSAf with much thanks in our hearts for taking on this rather difficult task. We as USAf decided that in creating a code which also dealt with research, we might have complicated future efforts. So remember, this is back in 2019. And that might have led to double work, for example, or requiring a revision or significant edit to the USAf, what became the guidelines, if a research code was to emerge. And then, of course, a whole host of other research-related standards, pieces of legislation, fell outside of university structures. So we opted to explicitly exclude research from our guidelines, instead focusing on the operational and administrative side of universities. So universities are indeed research intensive, but that's not all they do. And so we view the ASSAf Compliance Framework as complementary to the USAf POPIA guidelines. The ASSAf framework, for example, addresses what we know as a gap in the research space. It targets a different audience, researchers, rather than the professional and administrative staff of the university or the operations of the university. It also clarifies interactions between POPIA and other legislation, which we, from a USAf point, couldn't necessarily do to the same extent, such as the Health Act. And last year, in 2023, on behalf of USAf, our CEO, Dr. Petiwe, declared the USAf support for the then draft ASSAf code before it went to the regulator. As we are in the tail end of 2024 now, USAf intends to continue their support for the framework as it is. And with that, it summarizes this very similar journey that universities took. And I'd like to extend our appreciation to the ASSAf team for the work they've done to date. Chair, that's it from my side for now. Back to you.
Great, thank you very much, Jerall. Yeah, you again highlighting USAf's journey, which is a parallel process to that of ASSAf's as well. And USAf, should I say, correctly identified to focus on the operational administration side of a university, and for ASSAf to focus on the research side. And we do, as you highlighted, that we do need to work hand in hand so that the USAf guidelines is complementary to that of the ASSAf framework as well. And I thank you for your presentation. Thank you, Jerall. Our next presenter is Professor Penelope Engel-Hills, who holds the position of adjunct professor at the Cape Peninsula University of Technology. In this capacity, she serves on the Faculty of Health and Wellness Science Research Ethics Committees and currently has a ministerial appointment as the chairperson of the National Health Research Ethics Council. It is in this capacity that Penelope presents at this session of ASSAf. Over to you. Thank you, Penelope.
Thank you very much, Eleni, for that warm introduction, and thank you ASSAf for inviting me as the chairperson of our National Health Research Ethics Council. Let me share my slides and hope that they are visible. Go to presenter mode, and then I'd just like to check that you can see my slides and also hear me.
Yes, we can see your slides. Perfect.
Thank you so much for that, Eleni. That's always reassuring. The technology is is always the stressful part. So good morning, everybody. And I have really appreciated listening to the first three presenters. I think it really endorses the way that we all need to work together There's no one-stop shop, and there's no place that our researchers can go to, in fact, for all of the information. And yet we need to somehow be aligned and work together. So huge appreciation to everybody involved. I will quickly just give you a little bit of an introduction to the NHREC, our National Health Research Ethics Council. We've heard a little bit about the National Health Act. It's been in a couple of slides this morning. This council was established in terms of Section 72 of the National Health Act. And it has a prescribed mandate. So we're a regulatory council. And this mandate includes that we determine guidelines to facilitate best practice for our research ethics committees. So our sort of main target audience are research ethics committees. And I think this is an important difference and distinction, but it's also what brings us together. So we then register and audit these registered research ethics committees. And just to say that all research ethics committees reviewing and approving health research in the country must be registered with the council. There are other research ethics committees that choose to be registered, but all those reviewing health must be. So then we also adjudicate complaints, those specifically about RECs, and also those where researchers think they've had unfair treatment by ethics committees. Then importantly, we set norms and standards for research on humans and on animals, although today animals is certainly not our focus, but they're a very important part of the work of the council. And then we also have norms and standards for conducting clinical trials, and so work very closely there with SAMRC as another regulatory body that governs clinical trials in the country. So perhaps the next thing that I want to say is that, as was stated, thank you for mentioning, but yes, our council has put out the South African Ethics in Health Research Guidelines. This is the 3rd edition, and it's dated this year, having been sort of first put out in May this year, or sort of finally published in May this year after years of working on it and many consultations, and then launched by the minister in August, in fact by the DG, but signed off by the minister in August this year. Within this document, therefore, we have no specific reference to the framework. As we were working through it over the years, we had inserted reference to a code of conduct. I think we had wise guidance that said to not leave that in with the final publication, and that was the correct decision. Because we're now in the position where we have, in fact, I think, something which is going to be stronger in terms of taking us forward for the protection of personal information, and that is the framework that's been put forward by ASSAf now. And congratulations on that document. I just think it reads easily. It's somehow you can navigate it. I'm really impressed with the job done. So thank you for that. But in our guidelines, we do have reference to POPIA. And so that is there solidly. And so through that, obviously, then the framework will become certainly a component of the documentation that we would expect our research ethics committees and our researchers to refer to. So really, I think as we add these sort of layers of regulation and protection, I think that's what we're doing. And so I like that that notion that we become a safe haven for data, for I think, and recognized for that. And I think that is a strength. So for me, POPIA and our National Department of Health Ethics Guidelines 2024, which our shorthand is NDOH 2024, for that document. I think what we do is we sit at that interface now between the legal certainty and the ethical practice for the protection of personal information, and it's an important place for both organizations, both entities, and all of us to know that we actually have the support. So we have the ethical support and the legal support. ASSAf, of course, is a voluntary compliance framework, and I think that's an important notion. I think when it's best practice and it's voluntary, it really drives home that those of us that want quality research, those of us that want to protect our participants and by extension the data that is generated, we will choose to follow and to adopt the framework. And so, on the other hand, our as a regulatory body, the council, our document is compliance driven, and yet it's based on principles approach to ethics. So it's an interesting document in itself, that some components of it are very much steeped in the ethics principles, and therefore have opportunity for debate and some sort of different working out of the principles, but there are some areas that are for surely compliance driven. So there is alignment between the two, and I think the alignment comes because of our focus on research ethics committees and approval and review. And we need the framework, which is really directed for our researchers very much. Yes, institutions as well, but in our case, we're really grateful to have this document that guides the researchers so well. Informed consent is the place that we sit together, because informed consent is very important as the contractual agreement between our researchers and our participants, that they have the right to voluntary participation and, of course, the rights to the protection of the personal information and the processing of that. And so in the proper administration of research, we're very concerned for that, because that's certainly an ethical issue as much as it's a practice issue. And so guidance on that for researchers is really welcomed. And also the notion of risk analysis, although the risk analysis from the POPIA and therefore from the framework perspective has a different dimension to it. We have risk analysis in terms of the risk-benefit analysis to see, is this ethical research? Yet what happens is that the framework put out by ASSAf and promoting this idea of risk analysis being so important in research is again something that we welcome and appreciate, because it furthers that awareness. So as I close, I'll just say that, if I see the sort of roadmap through research, and I see the framework taking researchers so nicely through all the phases of research, and then our Ethics Council also being interested in all the phases. So we're interested in scientific approval as a starting point, and then ethics approval, and certainly the scientific approval and the ethics approval are guided by the ASSAf framework. Site approval, we would add to that, and that's where the institutions become involved, and our research sites. Certainly, the informed consent is where we come together. We're at the individual base of informed consent, and POPIA in a sense is a different, slightly legal consent, knowing that POPIA, that our researchers adhere to POPIA and comply. And so we need two aspects to informed consent now in research, and we certainly speak to that in our document, and refer to POPIA, and will in future refer to the framework. And then there's monitoring and integrity, monitoring of the researchers, and then the integrity of our researchers, and post-processing. And I think in all of those sort of phases and places, we have 2 guiding documents now, together with all the other guiding documents in the country. And so with that, I thank you again for allowing me to be with you this morning. Back to you, Eleni.
Great, thanks very much, Penelope, and thanks for the presentation and for the NHREC support of this process to ensure that the protection of data and in turn the protection of our research participants is in place. We need to ensure that the NHREC guidelines as well as the ASSAf framework do align, as you mentioned, with each other to uphold the best practices in research. And to have reliable research at the end of the day, because that is the bread and butter of our researchers and our innovators. And one thing that you are correct on is that the key to this is the informed consent and the POPIA consent at the end of the day. So I thank you very much for your presentation, Penelope. And having said that, I'm now going to be handing over to Michèle to put some questions to the panel to get the discussion going. Over to you. Thanks, Michèle.
Thank you so much, Eleni, and thank you to our 4 speakers. I think you've all beautifully articulated, how this voluntary framework for POPIA compliance and research will dovetail with the initiatives that you have in your own organizations. Thank you so much for all putting your cameras on so that we can see you for this, this next session, which is the panel discussion. Which will be about 20 minutes, and then we'll hand over to our audience to pose questions. So great. Have we got everybody on here? So we have 3 questions, and we'll deal with each of them in series, and would like to have your views, and we'll go around the panel to actually sort of say how you feel about it. So the first question is, in your view, what do you think are the key enablers for the adoption of this voluntary framework by your members and your stakeholders? So I wonder, Ms. Zwane, could we ask you to perhaps start? I don't know if you want to also just put your camera on again. Thank you so much, and thanks for your wise words earlier and that really nice contextualization within the Department of Science and Industry, Innovation.
Thank you. I think it would be its continuous support. I think from a government perspective is that we are quite vocal about where we stand with regards to the framework. And also importantly is to make sure that even in the adoption, it is not done at the expense of our research and growing the sector. So it's important that we create awareness out there. It could be through our stakeholders. It could be also as a department ourselves when we get an opportunity to do so. But the question would always be, what are the risks in terms of encouraging the sector to continue and the uptake of research and so on? Yes, but importantly is that we are not doing this at the risk of the research sector itself, but to make everyone understand that it is a regulation which we need to follow within the context of what we can do, but also most importantly, encouraging is that the more we adapt or comply, it's easier for other stakeholders who are outside of the country even to be role players or to partner with us to grow the sector in terms of foreign investments and other areas of collaboration which we may engage in. Thanks.
Thank you very much. And Professor Ntusi, your thoughts about the MRC stakeholders?
Thanks very much, Michèle. So I've given quite a bit of thought to this question over the last week, and I think there are 7 key areas to enable adoption of this framework. The first relates to the standardization of procedures by establishing identical protocols and procedures that staff members must adhere to. Operating manuals will assist to ensure that jobs are carried out consistently across all institutions in the country. So that's the first area. The second relates to training and onboarding. And I think that these guidelines are crucial in providing uniform training for new hires, giving them knowledge that they need to swiftly and efficiently comprehend their duties and responsibilities, but ultimately are critical in enabling a compliance across the sector. Third, I think this framework will be important in enhancing efficiency and productivity. And so the use of this guidance may help to eliminate mistakes and simplify processes across our institutions. And I think fourth, it's absolutely critical to ensure quality assurance in a standardized way. So guaranteeing that all activities will adhere to uniform quality standards. And number five, it's key to facilitate communication, providing a direct line of communication on policies and processes, which help to cut down on miscommunication, but importantly, to also enhance teamwork. Number six, I think it's critical for knowledge preservation. So by capturing and recording institutional knowledge, we can ensure that this knowledge is kept safe, available in the event that important personnel are departing an institution. And then finally, it's key for compliance and risk management, as has been discussed earlier. And so ensuring that we meet our legal and practice obligations and reduce risk by defining compliance in a clear way. Thank you so much.
Thank you so much, Professor Ntusi. Clearly a lot of thought into that. And I think what you're highlighting are really some of the things we had in mind when developing this guideline, is that it would be an enabler for all of those issues. And now I'd like to go over to Mr. Toy, your thoughts in terms of USAf.
Thanks, Prof. One of the things, or one of the strong enablers, I believe, for the ASSAf framework is the specificity of it. As an example, it's one thing to talk about when we talk about POPIA and the GDPR and data protection in general, many thoughts go to the digital space. But the physical threats are always of concern too. And from a USAf guidelines point, we could say this is how you should consider physical security in terms of your office space. But where the ASSAf framework comes into place, it helps our researchers think, what about my paper notes going from the research site to the point where I meet my Uber that's going to take me back to the office? And that level of specificity, I think, is really going to help our researchers produce more holistic and considered research protocols, for example, and also in their data management methods. So I think that's going to be of a huge boon to all research endeavors in South Africa.
Thank you so much. That's really interesting, that emphasis on security. But, you know, again, thinking about how we are responsible in terms of how we, you know, look after our data and also protect our participants' personal information. So now I can go over to Professor Engel-Hills. Your thoughts?
Thank you, Prof. So I think well covered by previous speakers, but the couple of things that I would then like to add is to, actually stress again that I think what ASSAf has managed to produce is a very user-friendly and accessible document. And I think this is important. I like some of the hyperlinks, for instance, and I think those things really will enable researchers to use the document very effectively. So I think that for me is important. In terms of the National Health Research Ethics Council, our document published in 2024 came after then the promulgation of POPIA. So POPIA is therefore a component of, in fact, an important component of our guidelines. And by extension, then, the framework will become a key document for our research ethics committees and our researchers. And through that, we will then therefore enable POPIA, because this is accessible. I think it's, for most of us, or no, for many of us, the sort of legal is a little bit out of reach. And what this document does is interpret it for us as researchers, as research ethics committees. So thank you for that.
Thank you so much. And I think, this multidisciplinary approach to trying to understand how to unpack POPIA has been really important in this 4-year process that we've been through. And I think, the committee and all of you have learned a lot about, where we want to be and how we want to make sure that whatever we do is fit for purpose in terms of guidance. So I'm going to go on to my second question to the panel, and that is about thinking about the internationalization of research. And I think this was mentioned quite a bit by Ms. Zwane. So how could adopting this framework actually enhance the internationalization of research, including data sharing beyond our borders, to ensure South Africa's competitiveness in this global research stage? So Ms. Zwane, over to you for your comments.
I think, as said earlier, the framework is really more than a regulatory guideline, but however, a best practice model that will drive a consistent approach to data privacy of all bodies in South Africa, which then says that this model ensures that South African research will remain both ethically grounded and globally relevant. I think I'm just repeating myself here in terms of upholding rigorous data privacy standards, which fosters trust, public trust, strengthens our research capabilities, and also showing that we are committed as a country in leading by example in terms of working with other countries. I think I've said this even in my opening remarks, and it just remains a fact that this would open doors for us in being a trusted partner with the global community.
Thank you so much for those wise words. So let me hand over to Professor Ntusi.
Thanks, Michèle. So, POPIA is aligned with generally accepted data protection principles contained in international legal instruments and leading practices in foreign jurisdictions. And so these global data protection laws exhibit several similarities, although variations exist in their particular provisions. These similarities signify a worldwide acknowledgement of the need for protecting personal data in the digital era, despite each jurisdiction customizing its legal frameworks to tackle local difficulties and goals. And therefore, the way I see it, the implementation of this ASSAf POPIA framework will largely translate into the implementation of comparable international scientific, ethical, and legal principles and leading practices in data privacy protection globally. Thank you.
Thank you so much. I was really interested in your gap analysis when you spoke also about the inconsistencies with the European GDPR.
That's right.
And how we need to think about them and address them. But I'm hoping, that this guidance document will be aligned. But I think, Eleni also mentioned that we have an opportunity to be leaders in terms of, setting policy for the continent But I think what we do is important and will be looked at by many different people. And if we ever want to go for, you know, sort of that reciprocal environment, we need to make sure that we're aligned and that what we do is both responsible and aligns with international best practice. Just to say, yeah, to those who are putting up your hands, we'll give you a chance just after we've had the panel discussion to pose your questions. So looking forward to those as well. So if I can now could go over to Mr. Toy.
Oh, thanks, Prof. So from my side, I see many partnerships with European institutions, for example. And over there in Europe, there's a let's call them a higher level of familiarity with data protection impact assessments, with formalized guidance notes, etc., on how to run those. Whereas in South Africa, our guidance notes on personal information impact assessments are not yet at that same level of, let's call it accessibility to our average researcher, be it even an honors level researcher. And what the ASSAf framework does is it breaks down those risk and impact assessment methodologies in a way that our South African researchers will be better able to have those discussions with their international partners, be it perhaps the way in which we contribute to those assessments. Perhaps it speeds the assessments as well because we are more familiar on how to do those. And it overall increases our understanding of international expectations on our researchers too. And that can only be a good thing when it comes to ensuring the privacy of our research participants. So I think it's a good step forward, especially like that section of the framework.
That's really good to know. And you know, I think what Professor Ntusi was saying earlier was also the need for training. So hopefully, you know, this framework will also, you know, set the agenda for how to train and what to train on. And it is quite explicit in terms of the risk assessment and what one would look at. So hopefully that will be very helpful. So Professor Engel-Hills.
It's fine too. Yes, so from my side, I would just add again that for all health research in South Africa, no international researcher can work in this country, in fact, without a South African collaborator. So that's a really important positioning as a starting point. And with that, we also have important documents where we have data transfer agreement documents through the Department of Health, as well as materials transfer agreements, kind of the high end of personal information protection, I think, is the human biological material protection. And so we have those sort of structures in place. What was missing was the narrative to go with that, to guide, because it's one thing filling in a form and getting the permission, but to actually develop the integrity and the thinking around protection of personal information. And for me, that's really the strength. And I think we will encourage international researchers to be here, and we'll work with them. Our South African researchers will also be developed in a much more significant way to actually not only adhere to, but want to adhere to the protection of personal information. Thank you.
Thank you so much. I think research is becoming more global, and people are comparing, you know, between countries, and if we don't share our data, we can't be part of that. And also realizing that for South Africa to benefit maximally, we often do need to share our data for various purposes, you know, including now machine learning approaches. And, you know, although that can be quite scary sometimes, you know, we have to think about how we do that responsibly while still protecting personal information of the participants. But it's very good to have an enabling mechanism, which is what we're really trying to build through this guidance framework. So I'm going to come to the last question now to the panelists, and that is to ask you and this has been addressed in part about, whether you have identified potential gaps in your stakeholder community that might be specific to your stakeholders in this POPIA framework, because we'd like to know and we'd like to address them. And Professor Ntusi, I know that you gave us 3 really, or 4, I think, sort of gaps that you had identified. But just to keep the sequence, let me ask Ms. Zwane, please, to comment if she has identified on behalf of the Department of Science and Innovation any gaps that we should still be considering.
Maybe not at this stage, but the voluntary part in terms of the framework. But at the same time, you do want people to adapt to something over time without necessarily enforcing it. And hopefully through the others that have adopted, they could share some evidence in terms of benefits. And then with that, you would find that more people are kind of like deciding to adjust or to comply with the framework. But it is a gap, but it's not at this moment a train smash, as we are all trying to get into this and adapt to it and see how it works. Maybe over time, it can be elevated to another status, but based on the data that would be available at that time, it may be necessary to perhaps look at in terms of if it needs to be compulsory or if it just remains voluntary. But at this stage, it's a gap that we see, but not that we can do much about it at this stage up until there's implementation and there's evidence in terms of what then happens going forward. And then probably at that time, things can be more standardized and so on. Yeah, thanks.
Thank you so much, because I think we do think of this as a living document that evolves with time. But, it's a very good starting point. And as you say, it continues to be voluntary, but one would like to encourage everybody to buy in. So Professor Ntusi, any additional gaps you'd like to highlight or maybe restate some of your previous ones?
No, very briefly, I won't repeat my earlier comments, which are summarized in the final slide of my presentation, but really just to say that as I've described, you'll see that there's a very strong alignment between the approach we've taken as the SAMRC with the framework that ASSAf has produced. And I think that given the extensive investment in developing both our institutional policies, frameworks, but also practice in this area, we are very happy to share our experience with other institutions that may be at different journeys of engaging with how they ensure compliance with POPIA.
Thank you so much. And Mr. Toy.
Thanks, Prof. So from my side, I think it's about monitoring and addressing potential unintended consequences. And so, for example, under the section for responsible parties, a researcher and a university may be joint responsible parties for a particular initiative. And that might sound very, very scary to an honors level researcher. And we don't want to block meaningful research because a researcher is a bit afraid or too unsure about how to approach it. So a potential gap is, how do we address that proactively rather than have a generation of honor students avoiding doing, let's call it, slightly higher value or slightly higher risk research. So that's going to be an interesting communication and training and awareness challenge, but one that we can't forget either.
Thank you so much. I think leadership in that area is really important. So, the training and awareness at all levels. I like that you even talk about honor students, because they too are researchers, but of course need to be guided by their supervisors. So, you know, we need to think about how the message goes through to everybody. Great. So Professor Engel-Hills.
I think for me, an important concept is that no single document can do everything. And so we need to be encouraging our researchers to take on this framework as an additional resource, a very important additional resource. And so I don't so much see gaps, although I will read it again after this with a little bit more insight and awareness, and give it the attention it deserves, and certainly would come back to you if I notice any particular gaps. I think for me, again, to say that we as a council focus on our research ethics committees, here the focus is very clearly for the researchers, and yet both must be encouraged to refer to both documents, because that's what it needs. I just want to mention in terms of Gugulethu's statement, I think it is that sort of voluntary approach is an important aspect. And so perhaps in some ways for me, from the ethics perspective, building in from ethics principles, I mean, yes, it might be voluntary, but it's a moral obligation. And so I think there is some sort of place to really encourage our researchers to take it on. And once having taken it on voluntarily, then you're committed to it and you adhere to it. It's not then cherry picking which parts you want to adhere to and comply with. So thank you.
Thank you so much, because, you know, one of the questions we raised was if somebody does not decide to comply with this guidance document, the question should be asked why. And as you say, that may reflect that there's some concern in terms of either not understanding or not sort of having the wish to be, you know, compliant and ethically sound. I think, you know, what we've tried to do in the previous code of conduct and now in this voluntary framework is to make everybody aware of what they should be looking at. You know, when they go through the risk assessment, the informed consent and all of that, we haven't been prescriptive in terms of exactly how it should be done, because we're very mindful that not all institutions have the same resources to actually implement. And we hope that there will be, you know, sharing and cross-learning, but not to be prescriptive on exactly how it should be done, but so that everybody's aware of what should be thought about and what needs to be included, at least at a certain level. So I think with that, I'm just going to thank the panelists for addressing these questions, and I'm going to hand back now to Eleni, who will be chairing the Q&A from the general participants here. Over to you, Eleni.
Thanks very much, Michèle. But if I can ask you, Michèle, and the panel, and if I can ask Sarah as well to join in this discussion, because there are a mixture of questions that are for the different stakeholders and that. And I'm just going to go through the written ones, but if there are any questions that anyone would like to ask in person, live, please do put your hand up as we go along. First question is from Leslie Mayer. Although this question is not linked with research, it is linked with POPIA Act, in that I would like clarity on how to protect patient clinical notes. And I think if I can ask Ntusi to take that one, please.
So POPIA is quite specific around how we protect patient information, and I guess the question is asking specifically around sharing of patient notes with insurance companies, and there's legislation, I believe, that guides how that should happen, but POPIA should always supersede any other legislation in relation to protection of personal information, and I think the guidance is fairly clear. I'm not sure if there's a specific scenario that he wants to pertain to.
No, it was just a general question. Thank you very much, Prof. Great. Another question that comes about, again, from Leslie. She speaks about the background of during audits, medical schemes insist that patient clinical notes must be handed over without redaction. The scheme goes through to determine that clinical notes collaborate with the billing charged. However, according to the HSPCA, notes must be handed over, but yet court rulings have suggested that notes should only be handed over when patients are joining the scheme, but that private notes should be kept confidential if the patient has attended in their private capacity. I'd like to clarify on this, or perhaps research into this. Any comment on that, Prof. Ntusi?
Yeah, so my reading of the legislation is that POPIA should supersede those court rulings and forcing clinicians to share unredacted patients' personal information with insurance companies. I would defer, obviously, to lawyers in this area, but the way I understand the legislation is that POPIA is sort of at the top of the food chain legislatively around how we protect patient information, and this applies to how information is shared with funders as well.
Great, thank you very much. A question for Penelope. Does our local NHREC need to approve the POPIA consent form? So, Penelope, sorry, you on mute?
Thank you. At least you could see I was talking there, or trying. So yes, if we're dealing with health research, so our NHRECs in health research, we would certainly be saying that that the REC should see that there's going to be informed consent for the POPIA side, and that because there's really a single engagement then with your participants, and you have the opportunity to do all your research informed consent and explain that, and the POPIA consent is fairly short. I mean, it's not a big thing because we're not expecting our participants by any means to become conversant with the POPIA Act. But they need to know that there is the Act and that the researchers comply with the protection of their personal information and sign that off. So I would say, yes, I would suggest that the NHRECs do see that that's in place. It would be an ethical thing to do as well. Thank you.
Okay, great. Thanks very much, Penelope. I mean, it would be the central point, basically, of reviewing that all in one go and applying their minds while doing the ethical review as well. Thank you. The next question is, if a participant in research is given a pseudonym to protect their identity, but all other demographic data are provided, example, age, gender, diagnosis, clinical, where treated, etc. Is this sufficient in terms of POPIA, as surely individuals known to them might identify them? I see, Jerall, you've got your hand up.
Yes, it's a favorite topic of mine. So when I'm faced with these, I like to consider the re-identification risk. So how easily would the individual be re-identified by somebody that knows them, or somebody who knows the population group under study, etc. And that informs your risk assessment, to what extent it helps you comply with POPIA. As the only control in your arsenal, more than likely you're going to need multiple controls. And when it comes to anonymity in general, the European Working Party on Data Protection, way back in 2014, released an opinion on anonymization techniques and the related re-identification risks. So if you can find that one, it's pretty easy to find it on your favorite search engine. It's not without its criticisms, but it provides a lot of guidance. And I know more recently, and well, I hope I'm not putting Sarah on the spot, but I think last year in the European Court of Justice, there was a case with, I think it was a financial institution going under an administration, and they handed certain pseudonymized information to an accounting firm to help them with that process. And that judgment also discussed what is adequate in terms of anonymity. So if I can find those, I'll pop them in the chat. I hope I got those right, and I'll dig them up and I'll put the links in the chat for us.
Great, perfect. Thanks, Jerall. That would be great. Thank you. The next question is the POPI body compulsory at institutional levels? If so, what are the selection requirements? I think, Sarah, I'm going to ask you if you can go for that one, please.
Yes, I just want to clarify what is the speaker asking about when it says POPIA body? Are they talking about a specific group within the institution? I think if you are, then it is always advisable to have some sort of POPIA committee, especially if it's a large institution, to have that. Just to do the monitoring. It could just be someone in legal and compliance who is also there. It's not legally required, but obviously you are legally required to have an information officer, and that person has to be registered with the Information Regulator. And the selection requirements, it will obviously very much differ from organization to organization. But yeah, I hope that does answer a little bit. If I made a mistake with understanding what you mean by POPIA body, please just let me know. Thanks.
Great. Thanks very much, Sarah. I think the next one, if you can take it as well. In practical terms, how should POPI consent be obtained from a partially or fully incapacitated adult patient? The framework does not seem to accommodate nuances.
Yeah, this is a fantastic question. So I think it's right there in the first one, POPIA consent. So if you have a look what are the requirements for consent are, it has to be voluntary, specific, and informed and explicit. So in my opinion, legally, you can't actually get POPIA consent from an incapacitated patient. You'd have to rely on one of the other legal justifications to process that personal information, but you definitely can't be relying on consent for that. You could be relying on your informed consent for your research activities, and get informed consent from possibly a member of the family. But POPIA consent, POPI is very specific and very clear what it means when it comes to active, informed, voluntary from the data subject. Yeah, so sadly you can't rely on that one. Sorry, Anne.
Okay, great, thanks, Sarah. I see we had a hand up. I'm not sure if it's up anymore, but I can't really see. I just see a message that comes up. Untitled. Would you like to unmute and ask a question?
Yes, thank you very much. Thank you very much to all the presenters today. Just to note potential gaps which I have noted after going through the framework and also on the presentation. I have identified that there is a gap on the requirement relating to Section 57, which deals with the prior authorization, where a researcher or an institute processes personal information that relate to unique identifiers. There is a sentence that speaks to unique identifiers, but it's not broad enough, and it does not address the issues relating to Section 57. So I think one of the things that needs to be considered on the framework is the Section 57 requirement, which deals with prior authorization, and also on the complaints procedure in terms of Section 74 of the Act, which is a compulsory requirement that the regulator need every institution that processes personal information or anyone that processes personal information to consider that they should be having a complaints procedure. And also I've noticed that you have touched on the PIA manual, but the document is silent with the privacy policy of the institute. So those are the gaps that I have identified. And there's also a section that deals with records retention, which I believe that is very broad. It cannot be dealt with by a clause, but it needs a policy itself to expand on your records retention. How do you handle it? And from the point of inception up to destruction. Thank you so much.
Great. Thanks very much, Amati. Those are some good points. Sarah, would you like to address those?
No, I think we'll take that on board and have a look at it. And yeah, just one thing on the records retention. We obviously can't provide the whole policy for you, and everyone will be different. So I think the recommendation was to actually include that and think about it. But yeah, thank you very much for those points. I've jotted them down, and we will make sure that they are addressed. Thank you.
Great. Thanks very much, Sarah. The next question goes on, and it speaks about, although this code of conduct of POPI does not currently have specific coverage of AI other than section 71 that deals with ADM, and one can probably infer some ML processing. Has any thought been contemplated on the use of AI and its privacy implications on research? Go for
Eleni,
it,
yeah, I'm happy to take that. So yeah, AI is in the background of all of our minds when we're doing this, and even though it's AI doing some of the research, or we're using AI to do it, all of the principles still apply. So if we're using an AI tool, they would be an operator that we're using, then you have a look at the operator requirements, make sure you sign an operator agreement, all of that. And if you're inputting personal information into the AI tool, also think about what those implications. Read the terms and conditions, make sure that you treat them just the same as you would any other third-party operator. So definitely, we have really thought about how AI is happening in the background of everything. I mean, AI is happening right now with recording and with with most probably transcriptions in the background. So yes, a lot of thoughts have gone into it, and the good thing is that it doesn't really affect it that much because all of the principles still apply.
Great, thanks. Just to build on that, just another question. Does the document provide researchers guidance around the use of data and AI, particularly around patient medical data?
It doesn't, because we haven't gone into any specific area of research. So if we spoke about medical data, then we'd have to look at possibly genetic data. So it broadly applies, but no specific guidance. It would be a good one for an FAQ, and maybe that anonymous person could write a nice specific case study for us, which we could then potentially apply to. Thanks.
Great. Thanks very much, Sarah. Not off the hook as yet. The next questions are, will the Information Regulator be approached for comment on the framework? This is because ASSAF's interpretation of some of the provisions of POPI, example, legitimate interest, may be different from the interpretation of the Information Regulator. And then a second question to that is, what is the latest situation regarding the Code of Conduct application?
Okay, good questions. The Information Regulator does not actually make comments on frameworks. They only make comments on Code of Conduct. So we did ask them, but they have said that it's not within their scope to do that. So we have tried, but they are unwilling to do that, and I understand that they can't comment on every single framework because there are quite a few. And our interpretation might be slightly different, but then again, a legitimate interest, we have made it fairly broad because you have to apply that sort of test in every single scenario, which is what the Information Regulator actually also recommends. So they also would not give specific instructions on what legitimate interests means, because it applies in each and every unique situation. And then what's the latest situation regarding the code of conduct, which is the code of conduct application?
I think just about the code of conduct that we previously had in place, and we were
okay.
Yeah.
Thank you for clarifying that, Eleni. So the code, is no longer going ahead. They are aware of it, and they know that we've changed directions and are going with the framework. So the code of conduct applications is not going forward. It would never be passed. Just to touch on what Michèle said originally, because if it was passed, it would only apply to the ASSAf specific researchers, which obviously we didn't want. We wanted it to be a much broader thing. So that's the application's no longer going ahead, and it will be the framework. Thank you.
Okay, great. Thanks very much. We literally have 5 more minutes, so I'm just going to try to see if we can get through as many questions. But questions will be answered afterwards as well. Will compliance to the framework be expected from all universities, and how will you ensure this? This is important how an institution formulates this in their guidance, documents, and policies. I don't know if Sarah, if you want to take it, or Jerall.
I think Jerall, you go for it.
Yeah, I'll take it. So as I understand, this framework is still going under a period of public consultation and commentary. And once the next version is released, the USAf board will make a decision whether to adopt it as USAf or not. If they do not, then each individual institution under USAf, I'm only talking about the public universities of South Africa, they will need to make a decision as an institution whether they will adopt it or not, probably at the council level. If USAf as a whole adopts it, then it applies to all its members, which would be all 26 universities. And based on my conversations with the CEO of USAf, there is full intent to adopt it. How will you ensure this? Well, monitoring and evaluation is always the big question. And that's going to vary from institution to institution, depending on the capacity they have, how much research goes on there. So to give you a universal question now is quite tricky, but it's definitely, we're going to be thinking about this as part of the POPIA forum.
For sure. Great. Thanks, Jerall. Just, to link onto that response, why is the framework voluntary and not mandated?
Well, I think I can answer that, because you can't really force anyone to sign into a contract. So this is sort of almost a contract. You might say, sure, we'll sign on it just to show our support, but we can't mandate it because it's no longer going to be a code. If it was a code, then it would come from the Information Regulator. The Information Regulator, not come from, it would be endorsed by the Information Regulator. They would just essentially put their stamp of approval on it, and then it would apply. However, it would only apply to ASSAf researchers or the ASSAf institution. So that's why we made it into a framework, and a framework is by its very nature a voluntary document. We could change it into a contract, but I think, even as a lawyer, I want to stay clear of the legal terms. It's a nice voluntary framework, so you choose to join it. It will hopefully be seen as best practice because most people will be following it. So yeah, that's why it's not mandatory.
May I just add very quickly, Eleni, I really think the document is very aspirational, and what it seeks to do is to ensure not just best practice, but ethical practice and high quality research. And I think every researcher in this country who wants to be exemplary in how they engage around issues of data protection for participants in their studies really needs to be thinking critically about how they adopt all these core elements of the framework. And so I see it as voluntary, but really ethically really important for anybody conducting research.
Great. Thank you very much, Prof. Ntusi. It is an inspirational document, and it's come a long way. It's really walked a journey, and it will continue to walk that journey. And hopefully we can make it a better document with everyone's input as we go along. It is a living document, as Michèle mentioned earlier. So thank you very much. And our time is up for the Q&A, so I'm handing over to Michèle. And again, thank you to our panelists. Your expertise and skills in this area is fantastic, and looking forward to the framework. Thank you.
Thank you so much, Eleni.
Yes, Michèle.
Thank you to all our panelists. This really has been an excellent discussion. And thank you also to those of you online who've posed your questions. And, you know, this is just the beginning of the consultation on this particular document, the framework. And we look forward to your written inputs. And for those where we haven't been able to address your questions, we will certainly take them on board and consider them very carefully so that we can improve this document. We're also really looking forward to developing the frequently asked questions, because I think that they will help clarify a lot of the uncertainties that people have. So it's my pleasure now to hand over to Professor Himla Soodyall, who is the Executive Officer of the Academy of Science of South Africa. And thank you again, Himla, for your amazing support during this 4-year journey, which I think will actually never end. But we hope that we will have a framework that we can then put forward to be endorsed and accepted by all the researchers in South Africa. So thank you so much, and over to you, Himla.
Thanks, Michèle, and greetings to one and all, especially our panelists who have stayed with us the entire journey for this webinar. I must say it has been a long journey, and it is one that ASSAf could not have done without the unstinting support of the various members of the reference group and the drafting group. Prior to us consulting with the legal advice, our colleagues spent several human hours deliberating the act and having intensive discussions on the various components that affect researchers, particularly with respect to the protection of data, of individual participation, and so forth. And we've come a long way, and I really, really appreciate every single individual who put in the time to avail themselves for those discussions prior to coming up with a first draft, which we've discussed. We also are grateful to the public at large for their comments, and some have been very constructive, others have been critical, and others have even gone to press. But nonetheless, that is what open science is all about. ASSAf is a neutral body. One of our goals is to support academic research and to support members and academics in general. And when Michèle Ramsay brought the idea to us, it was without a blink of an eye that we agreed, because as a researcher myself, particularly one who's worked in the genomics field in population genetics, it was necessary for us to have such a guideline that we had envisaged at the very beginning. Thanks also to Sarah and the legal team for coming on board. I know it's been quite a journey, but nonetheless, the experience your team afforded us helped us to break across the jargon and to make the original document very user-friendly and easy for various sectors of the public to review and to internalize, and also to ask questions. It is quite incredible the amount of questions that have come through that my colleagues, Maputi and others, have had to field and put together and so that the teams could review and act on it accordingly. It is actually very sad that the Information Regulator did not see what the Academy was trying to do. We started the journey in full recognition that there were already processes at national level, at universities, the NHREC, the Medical Research Council, the Human Sciences Research Council, the NRF, and so on, who were already managing research and obviously had at the back of their heads the ethical processes, and particularly when the POPIA Act was promulgated, how this was going to affect research. I say it's a sad day because we were not trying to overstep on anybody's shoes. We've heard from our esteemed colleagues from the NHREC, the SAMRC, the DSTI, and USAf, how their individual streams and participation in the collective landscape comes together. Nonetheless, we bit the bullet, and when we've discussed this at council level, council was very supportive of the idea of a voluntary framework. I also wish to acknowledge the Department of Science, Technology and Innovation for their financial support in allowing us to pay for legal services to work with ASSAf and the two teams in drafting the final response. And we present this on a quarterly basis. From the time we started on this journey and engaged with the DSTI, with their full support and endorsement from the very beginning to take this on, when we report every quarter on the progress that we've made on this particular initiative. Nonetheless, I strongly believe that what we have put forward now in terms of the voluntary framework is another option for researchers to review and to try to grapple with the issues. The processes at university level through ethics committees, etc., still stand. The NHREC plays a vital role, as we've heard from Professor earlier, that they will continue to mandate the ethics at a national level on behalf of the Department of Health. The National Research Foundation, when they divvy out grants to academics, also has an ethics component that needs to be filled in response to those activities. So as we've heard, every statutory body is doing something to make the lives and the processes faced by academics to be that much better. And I am sure that this will continue in the future. And to what extent is the POPIA Act actually working? I mean, I'm sure many of you, like me, hate the fact that when you go to certain places and you have to produce your driver's license, they scan your car registration and your registration disc, and you sign on it, and they have all this information at the disposal. When you ask what you're going to do with it and how is it going to be dealt with, it's a security company providing that service to that particular organization. And all of this data is lost in the cyberspace. The same happens, when you go to a hotel and you have to register. They ask for your ID, you have to sign things. And I've asked this several times, what's going to happen with this information? Oh, well, we keep it for our records, etc. But how often do we get called by people we've never, ever had any engagement with, trying to sell us some policy, particularly car insurance, etc. And they've already got your data. So how is the POPIA Act actually working to serve us individuals at a societal level? It's a big open question. And here we are, with respect to research on human subjects, trying to close the gap, to ensure that protection, because we as an academic unit are very, very privileged to have at our disposal human subjects that avail themselves voluntarily to participate in our research. Were it not for them, we would never be able to conduct the research we have done in the multifaceted way that it happens in the current framework. So in closing, I just want to say once again, a very, very big thank you to every single individual who has participated, whether as part of the drafting team, the legal support, you as the audience who have responded to comments, to critique draft documents, etc., but more especially to my colleagues at ASSAf, who have worked across the 4 years to compile data, to ensure that you've been kept on, sharing information with respect to presentations and links, etc. And let's hope that the journey ahead is one that we walk together and that we view it as a collaborative way forward with the various stakeholders involved. And I thank you for your support previously and going forward. And we hope that, that the current document provides you with sufficient information as a one-stop stop to kind of orientate yourself into the nuances of what is required before you go into the heavy-duty documents from other sources to actually follow the protocol. With that, Michèle, I want to thank you and your teams and all the ASSAf staff once again for hosting this particular webinar. It's been well received by the number of individuals who have joined us, and I'm sure that many, many more who were unable to join us will benefit from the postings once the link is shared. All the best, go well, and have a good day forward. Bye for now.
Thank you so much, Himla. And I think with that, we conclude our proceedings on the Stakeholder Consultation Forum. Thank you, everybody. Goodbye.